Hi, everyone. Welcome to another episode of Open Mic. I am doing this one from Arizona, as you could see by the mountains behind me and the beautiful flowers. Today's a great episode with Chris Mumma, who's the executive director of the North Carolina Center on Actual Innocence. For nearly 2 decades, Chris has served as the center's executive director. She's been instrumental in fighting for criminal justice reform. She has spearheaded legislation on eyewitness identification, the recording of interrogations, preservation of biological evidence, and so much more. She's represented lots and lots of people, gotten them out of prison, gotten wrongful convictions overturned. We talk about one Willy Grimes case that is just a heartbreaking case. She's won a ton of awards. And you're not going to want to miss this episode. I learned a ton, so stay tuned.
You never know who you're going to see.
Be one guy one-on-one my whole career.
What you're going to hear.
Got a lot of desperate people in the city.
Or what they've got to say.
When you can take people inside of a crime.
That's what you're going to hear on my podcast, Open Mic. Find it where you find your podcasts. So, Chris, what I'd like you to tell our viewers is exactly how did you get started in the fight for justice for the wrongfully convicted?
Well, it's kind of a long road. I was actually on a death penalty jury when I was in finance. I worked in finance for 9 years before going to law school. And that was kind of my eye-opening experience with the justice system. Then while I was working at Northern Telecom, I worked on contracts and got interested in the corporate side of law. Went to law school thinking I would do corporate law. Ended up clerking at the North Carolina Supreme Court, and as part of business, we're always looking at continuous improvement, process improvement, improvement to the bottom line, improvement to customer service, improvement to outcomes. And I learned through my clerkship that is not really what the priorities of the justice system are. And so I became interested in process improvement in the justice system.
And you've had quite the career. I've followed you. I've looked at your website. You talk a lot about several reoccurring problems that are consistent in the wrongful convictions. The listeners and the watchers of Open Mic we've interviewed 6 or 7 different exonerees. We've talked about their wrongful convictions. So let's start with eyewitness identification. And so why don't you just lay out the problem? And, I've read that you've been able to create some new legislation in North Carolina that I'd love to hear about. Sure.
So eyewitness identification is always identified as the leading factor in wrongful convictions, but the fact is it's usually the beginning factor. So you can if you have a misidentification, that leads you down the wrong path, and that can lead to a false confession, and that can lead to forensic science, tunnel vision and investigations and analysis of forensic science. It can lead to a jailhouse informant. So oftentimes false identification branches out into other causation issues. So it's a key component of an investigation. And so it's critical that we do whatever we can to get it right in the beginning. We're never going to have 100% reliability in IDs because our minds are not recorders, and our memories are impacted by time and trauma and cross-race identification, whether it's white identifying black or black identifying white or black identifying Asian. We're more comfortable identifying features of people who are similar to the people we spend our time with. So in North Carolina, we were able, in 2008, we were we were the first state in the country to have statutory change statewide for the way lineups need to be conducted to increase the reliability of the identification to the extent that we can, doing things like presenting the identification in a sequential order versus simultaneous. So the viewer is using absolute judgment rather than relative judgment when they're comparing those photographs to their memory. And
hold on, slow down for a second. I don't understand what that means. So okay. Slow down on how either lineups in person or it's a photograph lineup. But what do you mean by sequential versus the other way?
So, typically in a law enforcement, a TV show, you'll see someone look at a lineup where the photographs or the people are presented lined up together, right? So they're holding a number, or so the witness or the victim is looking at all those people at the same time, and they're saying, okay, which one is closest to my memory? And so they're comparing each to each other to see which one is closest. Okay. And what we really want is the person to look at that individual in the photograph or live, and there's not many live lineups done these days, but and compare that image one at a time to their memory.
Okay, so that makes sense. That makes a lot of sense.
It's interesting because a lot of the criminal justice reform makes comments. It is common,
right?
Which is
imagine that.
Yeah, it's so frustrating about getting it passed because it makes complete sense. The other part of identification that makes complete sense is having somebody conduct the procedure who is not familiar with who the suspect is, right? So then they can't hold this one up a little longer, or say something like, take your time on this one, or anything, or even something unintentional like cough, which the witness or victim might take as a message when it's not meant to be a message.
So so that is part of the law that you got changed in North Carolina. They now have to show the victim or the witness one photograph or one live person at a time versus 5 or 6 like we see on TV?
That's right.
Interesting. And do you know how many states have adopted that? I mean, were you the first, did you say?
We were the first to have statutory change. New Jersey, the Attorney General took steps, but again, those were recommended best practices. And North Carolina, we issued those as best practices, but then actually law enforcement came back to us and said, listen, we need some consistency across the state. So if somebody conducts a lineup for us in a county next door using a different procedure, we can use it in our court system. So law enforcement actually asked for it to be made into statutory law. So the components are sequential, independent administration with standardized instructions for the witness and warnings like the investigation won't stop whether you make an identification or not. And that way the person doesn't feel this tremendous pressure that they're going to be the difference between the case being solved and not solved.
The new legislation that you were talking about, the witness identification, was that the only component of witness identification that was fixed in the new legislation?
No, it includes many components and it also addresses show-ups, which are inherently unreliable. That's when a crime is committed and in close in time and proximity, they take the witness or the victim to someone who has a similar appearance to what's been described as the perpetrator, and they show that one person to the victim or the witness, and that's inherently unreliable because the suggestibility of showing just one person is problematic. But
we've had cases where that has happened. All the things you're talking about, it's so interesting every time I do one of these, Chris, and I probably say this every time we do an episode, but they are so similar. The wrongful convictions follow a playbook. And I like how you described earlier about how the wrongful identification kind of leads to the tunnel vision, which leads to all of the other bad things that happen. And if you fix the wrongful ID, then the jailhouse snitches and the other bad things are less likely to happen. And that just makes a ton of sense to me.
Right. I think that's the case with eyewitness identification improvements, and I think that's the case with recording, because particularly now when everybody is so used to being recorded, right? We were recorded when we go to the grocery store, when we're at the ATM, when we're walking down the street. But yet what happens in closed doors in a law enforcement agencies is not recorded. How can that be? That something that impacts somebody's life is not recorded. So
are they recording lineups now?
Well, the legislation for the lineups recommends the recording for the lineups, but again, that law was passed in 2008, and the ability to record was very different then. Now, and the ability to store, right? So there was these concerns. You always have the concern the sky is going to fall when you try and do criminal justice reform, and the sky has yet to fall. The floodgates don't open, and none of those things happen that people say are going to happen. But now you can record very easily. They all have equipment in their departments, or they all have a cell phone in their pocket. And now we have cloud storage, and they don't have to say they need rooms to store all this stuff.
Yeah, there's no excuses. There's no excuses.
There's really not. All the complaints are being addressed, and they really don't have anything else to rely on. So I think the recording of all. There's a lot of states that have passed recording of interrogations, but there's hours of things that happen before that interrogation, right? So before they're read their rights. So in my very strong opinion is that all interviews inside of a detention, at a minimum, inside of a place of detention should be recorded from beginning to start, whether it's an interview or an interrogation. I mean, we actually should be recording everything that happens on the street, but let's start at least if someone's brought into the police station so that we have those 3 hours before the interrogation in addition to the interrogation.
That again makes a lot of sense. Let's talk about preservation of biological evidence. I know that you've been instrumental in getting some laws passed in North Carolina. What was the procedures that was happening, and what were you able to change?
So the preservation of biological evidence passed in 2001 in North Carolina, and that was at a time when the federal government under Janet Reno actually came out with recommendations for preservation. And what I've been involved in is improving that legislation over the years. It used to be that biological evidence meant blood or semen or sweat or spit. Now biological evidence includes fingerprints or something that somebody touched, because the sensitivity of testing has increased so much that you can get DNA from one's very, very small samples and two from skin cells. So as the science develops, the ability to use that science to identify a perpetrator increases. So evidence that was collected 30 years ago, we may not have had the science to test, but we have the science now. So it's important that it's important to keep it in custody or give notice of destruction. And that's the second part that people tend to skip over. It's not that we want law enforcement to keep everything. It's we want law enforcement to give the defendant notice that they're going to destroy, so the defendant can take action to either test or argue why it should be kept. So that's the part that tends to get ignored, is this evidence gets destroyed without notice to the defendant.
And I can't think of a better case. I know you've been involved in several exonerations, getting several people out of prison who were wrongfully convicted. And I've read about lots of your success, but the one case that almost has all of the elements that we're talking about is the Willy Grimes case.
Yes.
And I've read interviews with him. I've read interviews with you. I've read a lot of the articles that have been written. And as almost every single, exoneration that I've read about, they're heartbreaking, all of them, right?
Yes.
This one, I can't say is more heartbreaking, but it is extremely hard to read about the mistreatment and the corruption and the fraud and the what went on with his case, and the fact that he was able to, maintain his claims of innocence, which weren't claims, we were truthful claims of innocence, wouldn't take plea deals, wouldn't agree to admit to anything, even though he probably could have gotten out sooner. So I was very moved by the story. So I'd love you to set it up for our audience, and let's go through some of the BS that went on with this case and how you were able to finally get him out.
That's a good way to describe it. Actually, there's a book called The Ghost of an Innocent Man that is about Willy's story, and I highly recommend that to anybody who's interested in this topic. But you talk about Willy holding on to his innocence and not taking plea deals. But the other thing that Willy held on to that was always part of Willy was his grace. And when you meet Willy, you know right away that this is not a man who could have committed this horrible crime. He is a gentle soul, and that is the really one of the heartbreaking components of it is how much time, 25 years of this man life that was lost when he was the type of soul that he is. I often challenge people to tell me something that is worse than being in prison for a crime you didn't commit. And I've been through situations with family cancer and deaths and things like that. I cannot come up with anything that's worse. But in Willy's case, it does have the standard components of a cross-race identification, elderly white woman raped by a black male. So you have cross-race identification issues. You have trauma with the rape. You have a weapon, so you have weapon focus. You have short interval between the time the man broke into the house and when the trauma begins. So she wore glasses and she was not wearing her glasses. So
and she couldn't. I mean, there's so much here, and I don't mean to cut you off. I hate cutting people off, but I want to just break down. Let's talk about it. She could not identify him, and it turns out that the neighbor, who, I mean, I want you to go into the details about this neighbor. The neighbor identified wrongfully Willy.
Well, she didn't identify him. She was an informant for law enforcement. She knew all about rewards. She had a personal vendetta against Willy because her sister was dating Willy, and Willy was actually providing for her sister and her sister's son in a way that made this informant jealous. And Willy hung around the neighborhood, and so the neighbor went to the victim and said, "Hey, I think it might be this guy. What do you think about this guy?" And that became the guy.
Did she show him a picture of Willy?
Willy had come to the house once to use the phone, and so she referred to him in that way. But there were definitely things about Willy that would have made you remember, right? He had a large mole on his face that they called it like a grapevine or a patch of grapes that the victim did not recall. The victim said that she broke her fingernails scratching at the perpetrator, and Willy did not have any scratches. Willy has a scar on his chest. The perpetrator took off his shirt, and so there were a lot of indicators from the very beginning that she did not have an accurate description, and the height and the weight and that she first gave to the officer was changed once Willy became the suspect. And then she was shown a picture of the lineup on the stand, even though Willy was sitting there at the defense table, and she actually made the statement that she couldn't tell the difference because they all looked the same to her. So the racial component is amazing.
Is this the case where didn't she identify like the defense attorney in this case?
She said, when they said, "Can you identify him?" she said, "He's right there next to the man with the red shirt." And it was the defense attorney that she was pointing to. So,
so that is one of the craziest facts, and the fact that he was convicted based upon that. I mean, right there, if you don't have reasonable doubt, I don't. That is so infuriating. Did he tell me one thing that I didn't get a good sense of was the defense attorney. Usually, the defense attorneys are just the worst of the worst lawyers. They're usually disbarred not too long after these wrongful convictions.
It should be.
But or should be. No, and most of the cases, and at least the ones we've interviewed in Michigan, most of these lawyers are, they're either disciplined or disbarred, which is, of course, shocking to me, but, or maybe it shouldn't be shocking because I've read these cross-examinations, which are 2-3 questions. But tell me about his defense attorney at trial. Was he court appointed? Was he retained? Was he good? Was he bad? I mean, what happened at trial?
So let me say, and I will be the first to admit that ineffective assistance of counsel is one of the leading causation issues in these cases. But let me also point out that appointed counsel are typically very underpaid and have very few resources. And so we have an overloaded, underfunded justice system where the people who need the representation the most are getting the least qualified people because we're not paying people correctly. But the really amazing thing about the attorney in this case was, you do read this transcript and you say, how did this happen? He was actually pretty good, and he actually, at the close of the case, he made a motion for DNA testing, and that was very early on in DNA, so it was kind of very forward thinking of him, and a great move. And then it ends, right? There's no follow-up on the judge says he'll take it under advisement, and the defense attorney doesn't follow up, and the judge doesn't follow up, and then the evidence is destroyed. So it's really, you had that moment to get to the truth, and it was lost.
Jeez, that's heartbreaking. So first we have a neighbor who's paid to give give up somebody she's jealous of, clearly the wrong man. He had 8 alibi witnesses who did they all testify that there's no way he could have been at the crime scene?
Yes, they did. They did.
Did that come across as reliable?
Well, unfortunately, you spend most of your time with friends and family. And so those are the people who are going to testify as your alibi witnesses. And those are the people where the jury's going to say, well, those are friends and family, so who can believe them? It's like they want you to have an alibi by a complete stranger. And I think race played into it, right? These were all Black individuals who were defending the Black man against the rape of a white woman. So I think all of that came into play. One of the most disturbing parts about this case, though, is that, and it is similar to other cases where the true perpetrator was basically under the nose of the investigators. And because of the tunnel vision, let's say because of the tunnel vision and because of the relationship with the lead investigator, the perpetrator's brother was on the police force, and the lead investigator was best friends with the perpetrator's brother.
Wow.
So when they showed a lineup to the victim with the true perpetrator in it, she did not identify him. All the other evidence that basically pointed to him was put into a file and kept out of the main file. So it's another one of those cases where the tunnel vision was incredible, and the inept investigation.
That is completely nuts. Let's talk about, in a rape, there are lots of, there's lots of biological evidence. So the rape kit, was it ever, there was no testing on it, or there wasn't? This is in the 80s, so there wasn't a lot of DNA testing, but did they ever?
No, there was this motion for DNA testing, which there was biological evidence that there was semen and sperm, but so if they had done DNA testing, even that early with DNA testing, it probably would have been one of the first DNA exoneration cases. But within 2 years, the rape kit, the sheets, all the evidence was destroyed, which was pretty standard practice. Once the appeal is final, then we must have gotten it right and all the challenges are over, so let's destroy everything and move on. So this case was fascinating because it was solved with the fingerprints when the rapist after the rapist raped this woman, he had the absolute gall to ask her to make him something to eat. She was praying and crying and very traumatized. And he said, never mind. He went to the kitchen and went through her fruit bowl of bananas and apples, and again had the gall to pick out the ones that weren't pleasing to him and put them on the side of the table, and took some bananas and an apple. The banana peels were found on the sidewalk as he walked out of the house. The apple core was found in the street, was actually collected by the lead investigator. Would have been a great source of saliva, and he took it back to the agency and threw it in the trash can for unknown reason. But when he touched those bananas and put them aside, they collected fingerprints, and the oil from the banana actually was a very good conduit for the prints. And those prints, although we were told for over years and years that all the evidence is destroyed and the fingerprints were not available, and it took the Innocence Inquiry Commission, which is a state agency here, it took their ability to go in and actually do a search. A lot of times we ask for evidence in cases and we get the reply there's nothing left when nobody even got up out of their chair to check. And the fingerprints were found in the investigative file, and they were run through APIS, which is the automated fingerprint indexing system, and hit on Albert Turner, who was lived in the neighborhood, was known for these for assaults, had a violent history, raped other people, other women. So serendipity came into play. A lot of times you see in these cases some type of divine intervention, serendipity, whatever you want to call it, that finally leads to justice.
Did he get convicted and charged with that crime?
He died. He was being looked at. He was charged, but he died before going forward to trial or anything.
But it was a clear match. I mean, it was him.
Yes, it was a clear match, and he eventually came up with a story that he had gone grocery shopping for her or something and had bought fruit the week before, and there was clearly a lie. This woman, her husband had died a year before. She did not allow anybody into the house. She had very few people that she trusted to come into the house. And we had to use evidence like, the bananas were green, so they definitely weren't a week old and things like that.
What was the fingerprints evidence used at trial, at the original trial?
The fingerprints were used at the original trial, and it was determined they did not match Willy, but they assumed they came from somebody in the grocery store. They actually never even compared them to the victim. So they knew Willy was excluded. But, you can write that off as, well, the cashier might have touched them, or somebody who put their fruit out might have touched them. So APIS, that's why these databases are so important, because they can lead to a match to someone who has this criminal history.
That is, so it was argued to the jury that it didn't match, but they didn't have a system, so they weren't able to find this Turner piece of garbage to show the jury that it was somebody else, or the police probably couldn't. I mean, they didn't. Well, they did
that the fingerprints were irrelevant. They just didn't. They had no relevance to the case. Her identification and the informant's information was more valuable, even though incredibly weak.
Right. So this Innocence Inquiry Commission, I mean, that was pretty darn. I don't know what the right word is. Forward thinking or innovative. Yeah. I mean, to say we're going to go in there and we're going to search your files. And so how did that come about? How did they get involved to do this?
Well, let me give a little, if you don't mind, me giving a little background on the Innocence Inquiry Commission, because again, it's one of those things that happened, and it's interesting, the history of it. When I clerked, I clerked for I. Beverly Lake, who is the Chief Justice of the North Carolina Supreme Court. And because of my corporate background and my finance background and his responsibility for the finances of the court system throughout the state, we've developed a very close relationship. My role kind of went beyond the normal boundaries of a clerkship. And when I left, while I was clerking for him, I had two cases in particular where I felt like the jury definitely got it wrong. I felt like there was evidence of innocence that was not fairly presented. And I kind of took those cases in my mind with me, and I had accepted jobs in law firms and talked to my criminal law professor about these cases and said, they're really eating at me. And that's when he suggested I come work with him on innocence cases and for free, and somehow that was a good idea. But what came out of that was my relationship with Justice Lake. And as Chief Justice, his primary focus was public confidence in the courts. And there's nothing that impacts public confidence more, weakens it, than a wrongful conviction. So our work was still tied together very closely. And we talked about these cases in the process quite a bit. And in 2002, he worked with me to establish a study commission, which is how we ended up in North Carolina with ID reform, improved preservation of biological evidence law, recording of interrogations, and then the Innocence Inquiry Commission, which was designed to address two primary issues. One was procedural bar. Once you go forward with a case post-conviction, that you basically get one bite at the apple. And if you don't take the biggest bite and present as much evidence as you possibly can, then you are procedurally barred from coming back again for another bite at the apple. The other was the evidence issue, where of the 22 cases, at one point there had been searches in 22 cases by the Innocence Commission, and they had found evidence that was reported as being destroyed or lost in 11 cases. So
wow. That is unbelievable.
It's a horrible statistic, and
horrible. 50%.
So we have since changed the law, improved the law, where if a custodian of evidence is requested, an inventory is requested by the defendant or the attorney for the defendant, that custodian has to provide a written statement that they did a search and there's nothing there. And when you have to sign your name to something where there could be a felony charge that follows it if you didn't do a proper search, it increases the reliability a little bit.
For sure.
That's one of the major advantages to the Innocence Inquiry Commission, is their ability to look for files and to look for evidence that defense attorneys are not able to do. They've proven very successful at that, but the question remains, why is that not part of our normal justice system? For
sure. I mean, it's it's just mind blowing, right? It's just the fact that they had to go in and search somebody else's evidence room it's just remarkable.
Yes. Well, there's so many examples of it. It's not remarkable anymore. It's just sad.
It is. So the Innocence Inquiry Commission, is this run by the state currently? I mean, this is a state-run organization. Is this?
It's an independent. It basically takes the case out of the adversarial system and puts it into an inquisitorial process, which is similar to what the UK has. So it temporarily removes the case for independent investigation, and then the case comes back. If there's some evidence, then the case comes back into the adversarial system. The legislation was written in 2005. It was very forward-thinking. Justice Lake was an incredible leader in getting the legislation passed. Had a lot of his very, very close friends who criticized him and said, what has gotten into your head? I love the idea. Just like anything else, when you get humans involved, a good idea can have problems. It needs some improvement. It needs some changes. Has not kept up with the changes in laws that we've had for the last 15 years. So at this point, if somebody goes through the commission, they actually have less access to their files than someone who doesn't go through the commission process. Willy Grimes is a great example to. Willy was in for 25 years. He was proven innocent, and the commission would not let him have access to his files. So again, defies common sense.
I've never heard of this. This is news to me. We don't have this in Michigan. In some of the other states that I've interviewed people, I've not heard of this. What's in vogue is the conviction integrity units inside the prosecutor offices, which I thought was forward thinking, just like we've used that word a few times today. And that's not an independent agency. I mean, that's having, that's having the fox in the hen house, for lack of a better term. But there's some really wonderful things, especially in Detroit, that are happening. I mean, they're doing such a wonderful job of going through these old files and righting wrongs. Do you have that? Do you have that in your jurisdiction?
That was basically the concept we came up with, right? Before the conviction integrity units were established, that was basically what we were trying to do. And it is the fox in the hen house if there's not cooperative effort, right? There's never going to be confidence in a review of a case if the prosecutor and law enforcement are looking at it behind closed doors and they say, hey, everything's okay here, no reason to be concerned. But if you're working cooperatively with defense attorneys who have a different perspective and a different way of looking at evidence, then you can have more confidence in the joint determination that a case is okay, that justice was served. So that's part of the element that is missing with the Innocence Inquiry Commission, is that cooperative nature, the transparency. I think if we could make those changes to the Innocence Inquiry Commission so that it was more of a statewide conviction integrity unit, which was our initial vision, then it would be a very good model.
So, you run the North Carolina Center on Actual Innocence. You said before we got on the podcast how busy you are. How many cases are you actually working on? And I'm curious what your impression is, like how many people are sitting in prison, I guess just in North Carolina, that you think are actually innocent?
Well, people ask for estimates, and I always say, it's more than a couple for sure. And if there's one, I mean, again, I can't think of anything worse. So it is a matter of finding the needles in the haystack, but they're very, very important needles. We currently have 134 active cases. Right now, our advanced case load, which is cases where we would really stand behind the innocence of somebody, is much higher than it's ever been. It's close to 20 cases.
Wow.
So their battles, these cases are, in North Carolina, it's not a cooperative effort. And, I always say I have brick marks on my forehead from beating my head against the wall. So I've been doing this over 20 years, and it is draining. It is frustrating. It is draining. And it's life consuming.
Chris, do you think it's getting better? So the reason I ask that is a lot of the people I've interviewed, a lot of the files I've gone through are older, 20, 30 years ago. Do you think that with the changes that you've helped make in North Carolina, and I guess I'm talking across the country too, but do you think it's getting better and it's getting harder to convict innocent people?
I definitely think it's getting better. I think in North Carolina, we established the Indigent Defense Services Commission in 2000, which increased education and standards for appointed counsel. So I think our defense bar is much stronger than it used to be. I think the science is helping. Our state lab, the statistic is about 25% of suspects are eliminated through DNA testing during the investigation. So without DNA testing, those people likely would have gone forward as suspects. So I think there's a lot of indications that the system the investigation process is getting better. I think that we still have a lot of work to do on the prosecution side of the process, where we are overcharging, and 95% of cases are pled out because people are threatened, or they need to get back to work, or they need to get back home. I mean, most of our work focuses on felonies. Misdemeanor rates of wrongful conviction are much, much higher than felonies. So I think the prosecution side needs to be changed, needs a lot of work. I don't think the culture has changed as much as it needs to. We are working on process, but the culture is what needs to be addressed, and that starts from the top. And I think more attention needs to be put on that, where it's okay for a law enforcement officer to stand up and say, hey, I worked on this case 5 years ago. I think there might be a problem here. It serves the victim to do that. It serves the wrongfully convicted. It serves the community with the perpetrator. So until we have a change in culture at the top of law enforcement and at the top of prosecution, I don't think the progress is going to be what we need it to be.
Well, God bless you and all the hard work and all the great work you're doing. Keep up the good work. Keep up the great work. Christine, Mumma, thank you for being on the show and giving us, our viewers and listeners, an idea of what's going on. We love to promote these things and let people know that if you're a witness, if you're on the jury, if you see something, that these things are out there. And I think public is more aware now that this is happening, that this has happened in the past, that wrongful convictions are real. There's a story that comes out almost every week, if not every day, of the Willy Grimes of the world. And I just think it's important to get the word out there. So thank you for being on the show.
I think one more word that needs to get out there, Mike, is that people are out there who know of wrongful convictions, right? They have information about cases, and they need to not be afraid to come forward. There's people that can help. There's people that can protect them. So people need to come forward with information they have about mistakes that have been made. That's
a great point. That happens once in a while, and it happens to happen more, because you're right. These shifty jailhouse informants and people IDing wrong people, and people can't ID the wrong person. If they don't know, they have to say they don't know, and on and on and on. There's so many things that need to be fixed. Right. And hopefully it will soon, with people like you at the helm of it all. So anyway, thank you.
To the forefront.
My pleasure. Thank you again.
All right. Take care. Bye-bye.
What an interesting episode with Chris Mumma. I learned a lot. Just going down this path of wrongful convictions, I can't believe it's still happening. The fact that she has over 130 cases, and how many more people are sitting in prison. I think she gave a great tip that if you are out there listening and you know that somebody's sitting in prison for something they didn't do, step up, find the courage, find someone that you can tell in law enforcement or the prosecutor's office, and get it done. These people, what is worse than sitting in prison for something that you did not commit? Thank you for watching. Thank you for listening. Share this episode, like this episode, comment, email me on something else you want to hear about. And we have our 100th episode that you're also not going to want to miss coming up very soon. So thank you and take care.